Hello, everybody. Welcome back. This time we're going to be talking about the U.S. Supreme Court. So the U.S. Supreme Court, when they make a decision, it is the law of the land. All right, that's it. They are the last stop. So when they rule, all the lower courts have to follow what the Supreme Court says. No other judicial body, no appellate court, no district court can overrule a decision that it makes. The court can, however, overrule itself. As you may be aware, there was a controversial overruling of itself not too long ago when the Roe versus Wade longstanding precedent was overruled by the U.S. Supreme Court. All right, so the U.S. Supreme Court's decision are the law of the land. No other court can overrule the Supreme Court decision. However, they can always overrule themselves. They are given this power through Article 3, Section 1 of the U.S. Constitution. In that article, it says the judicial power of the United States shall be vested in one Supreme Court and other such inferior courts as the Congress may from time to time ordain and establish. So Article 3, Section 1, in the balance of powers, gives the judicial power the right to be vested in the Supreme Court. Okay, so Article 3, Section 1 also says that judges, both of the Supreme and the inferior courts, shall hold office basically for life. They'll receive compensation, and they'll be there unless they do something really, 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 really bad. All right, so the U.S. Supreme Court has jurisdiction over two types of cases. Cases that it reach on appeal, so the district court case gets appealed to the appellate court, and then the appellate court's decision gets appealed to the U.S. Supreme Court. That's one way. Or a case which it has original jurisdiction. So that's pretty rare, but it does happen. There are certain instances where the court has original jurisdiction over a type of case. So you can get to the Supreme Court those two ways. All right. The concept of judicial review, all right, the court's power to review actions of other branches or levels of the government and invalidate legislation and executive orders are as being unconstitutional. So what the concept of judicial review means, the court has the power to look over any legislation or any executive order and determine if it is or if it is not constitutional. And if it is not constitutional, it can invalidate it. Right, so that's a lot of power, right? So the concept of judicial review, think about this. The courts have the power to review any statute, any executive order that's out there and invalidate that as being unconstitutional. And this power comes from the case of Marbury versus Madison. Marbury versus Madison was heard and decided in 1803, so it's been around for a long time. And this case, and I know you're going to be doing a brief on it, this case establishes that the U.S. Supreme Court has the authority to nullify and void any act of Congress that violates the Constitution. And with that, what's carried over on that is to invalidate or nullify or void any act of Congress, a statute, or any executive order. This was taken forward in 1816 in the case of Martin versus Hunter's lessee, where the Supreme Court again reviewed and reversed a state court decision. All right, so this means that, not only federal cases, the power of overruling federal legislation and executive orders, it also can overturn state executive orders and state legislation and state cases. All right, it has the power to review and revise state court decisions and can review pending state court cases. Okay, and determine whether they are constitutional or not. All right. The U.S. Supreme Court, right? The U.S. Supreme Court's decisions to review a case is almost, except in the original jurisdiction cases, discretionary, right? There are certain cases that have an appeal of right, right? But for the most part, the Supreme Court does not have to take your case. There is no automatic right to an appeal to the Supreme Court, as opposed to the appellate courts. If you're in a district court, you have an automatic right to appeal to the appellate division, but there's no automatic right to appeal from the appellate division to the Supreme Court. The Supreme Court receives around 7,000 requests to hear cases per year. They couldn't hear them all, right? So you have to file what they call a writ of certiorari, or writ, or cert, however you want to define it, and then the Supreme Court will decide based on that writ whether they want to hear your case or not. So out of that 7,000 cases, 7,000 writs that are certs that are sent to the Supreme Court, only about 80 to 90 cases are heard per year. Okay? The makeup of the Supreme Court. There are 9 justices on the Supreme Court. There's the Chief Justice and 8 Associate Justices. They are nominated by the President for appointment and then confirmed by the Senate. Again, back to this balance of powers type of thing. The President nominates somebody, and the Senate confirms. If you are confirmed, it is for life. Right, it is for life. It's a lifetime appointment. You can be impeached, right? There is an impeachment clause within the Constitution. So you can be impeached from your seat on the Supreme Court for any conviction of treason, bribery, or other high crimes and misdemeanors. All right, what high crimes and misdemeanors means, I don't know. All right, so but treason we know, bribery we know, and you can be impeached for those reasons. The current Chief Justice of the Supreme Court is John Roberts. And I also provide you with the list and a little bit about all the Associate Justices. You should read it. You should get to know them. You see what they're like. You see what their values are, those kind of things. And that kind of helps you decide whether you want to appeal a case because, this court is a little conservative. So you may not want to appeal a case to the Supreme Court because then that becomes the law of the land. Or if you may want to, in the same vein, you may want to appeal it to the Supreme Court because then it becomes law of the land. Okay? So just, you may want to familiarize yourself with who the justices are. All right. So the traditions and procedures of the Supreme Court. The term of the Supreme Court always begins on the first Monday in October and continues until around June or July when they finish hearing cases. And then they take the summer off. All right. People can go and watch a Supreme Court argument. You can. If you want to go down to D.C., you can go and watch the arguments in front of the Supreme Court. But all the decisions are made in private. They don't rule from the bench, so to speak. All right. So you can go there, you can sit, you can listen to the attorneys provide their arguments. You can listen to the judges, the justices, ask them questions. But they will always make their decision in private. They will not let you in on that deliberation. All right. All right, so the role of justices on the Supreme Court, basically, they read case briefs. All right, so when you're an attorney, you write your brief. You inform the court of what the law is and how it should be interpreted. All right, so a brief is a written statement by an attorney that summarizes the case and the laws and ruling that support your position. Different from our case briefs, but the case brief is different but similar. It summarizes the case, it tells the justices what the law is and how they should rule on these facts. Okay. They have oral argument where the attorneys come and argue. And this is basically a summarization of the Supreme Court's the briefs themselves. They try to emphasize particular key issues. Arguments they don't want attorneys going on and on and on. They're usually restricted to about 20, 30 minutes. And they're pretty strict about it. If they say 30 minutes, they mean 30 minutes. So if you're a plaintiff's counsel or on one side, you have 30 minutes, the other side will have 30 minutes. You may have a few minutes to rebut, but that's strictly up to the justices and how they want to do that. But they're going to limit you, right? They don't want you to going off on and on and on, but they're going to limit you to certain issues, and you, since you only have a certain amount of time, you have to argue to that point. Okay. After listening to oral argument, they'll conference with themselves, all right, and they'll decide. They'll discuss a final ruling on an issue, and then they'll submit a case decision or an opinion. Decisions can be as follows. They could be what they call per curiam. Right? That means that all the justices are okay with it. It's a brief, unsigned court opinion saying, yes, this is the ruling of the court. They can write full decisions or full opinions. All right, this is a statement by the court explaining the reasoning for its holding or decision in a certain case, right? And some of those decisions can be pretty lengthy. I read, there's some I've read that are over 100 pages long. All right, so full opinions, and I may ask you to read some opinions during this semester. Marbury versus Madison is an opinion of the court. Right, it's how they're deciding the issue before them. Within that, other justices can write concurring opinions. All right, they sign on, they agree with the ultimate decision in the opinion of the case, but they may get there for different reasons. All right, an opinion signed in which one or more members of the court agree with the majority, but for different reasons. But a justice can also submit a dissenting opinion. Right? This is saying, listen, I don't agree with this, and this is why. Right? It's a signed opinion in which one or more members disagree with the majority view. They're saying, this is ridiculous, they're wrong, I'm right, and this is why. Okay? Doesn't mean anything, because the majority opinion rules. That becomes the law of the land. The dissenting opinion is there for people like me, legal people who kind of go in there and try to want to get the nitty gritty. Why did they disagree? What is it about this case that they don't believe in? That kind of thing. Some relevant terms, just as we wrap up. Relevant terms, political questions. An issue the Supreme Court will allow the executive or legislative branch to decide. Right? The U.S. Supreme Court really doesn't want to get into political questions. That's for the politicians. Supreme Court needs to be an autonomous body, not an apolitical body. And remedy. All right, just so you know, is a judicial order enforcing a right or redressing a wrong. Those are our two terms for this video. If you have any further questions, comments, or criticisms, please always reach out to me. You know how to get me. Email, text, or call. Thank you. Take care.